The heart has gone out of me on this subject, the Constitution, the thing that defined America. Without it, we are without law. If the Constitution is not king, then slimy, slutty, corrupt politicians are king. Because there will be kings. Something is going to be in charge. Rule of law or rule of men. Guess which now? So the example that I would go to, if I ever talked about it specifically, which I have not done until now, the example that destroyed American exceptionalism is the Supreme Court and gay so-called marriage, something over 8 years ago now. Took me a long time to stop mourning. The Supreme Court created a new right, a new institution, a new constitution, and a new country. Apparently we were asleep. It turns out that we were the unworthy servant, given a talent which we buried, while the other side is the more worthy, the good and faithful servant to its cause, and it received its rich reward now, regardless of what is to come. Rather than be bold and resolute and fearless and energetic in our cause, we retreated into civility and adherence to rules and decorum, while they were brazen, fierce, and successful. Years ago, for some reason in my disparate readings in history, I came upon the tale of some sheik or pasha or emir who had purchased a pretty blue-eyed slave boy and wished, as was the custom, to enjoy some sodomy. A Western traveler inquired of the potentate how such an insertion might be achieved against a determinedly resistant sphincter. Steady pounding was the reply. No resolve is sufficient to resist constant pressure upon such a minor muscle, designed as it is to keep things in, not out. Test it yourself. I now believe it is inevitable that, given generational time, the left will always prevail. Erosion is a law of nature. Attrition is the greatest general. Degeneration is the rule of civilization. Entropy is universal. So 8 years ago now, the decree came forth like Haman in Persepolis. There was issued the irrefutable affirmation of the Supreme Court supremacy. And of course, at first, as is my way, I felt nothing, profound stillness, like the spirit brooding upon the deep. But I slipped the hold I have on myself and allowed emotion and judgment in, and concluded that this was truly the end of America, the end of American exceptionalism. We became, in the summer of 2015, just another country. This fact brought only a dull depression, nothing profound, which surprised me. About a day later, I realized that my timing was wrong. We stopped being America over 50 years ago with Roe v. Wade. Death to the unwanted babies. Life is far more important than the institution of marriage, which is just an artifact of changeable culture, as ours has changed or been changed. We allowed the Supreme Court to well and truly assert its supremacy with that power grab, that plunge into insanity, where life itself is defined as not meaningful, given a woman's right to what is called privacy. Point of order, the process, mechanisms of creating and birthing a child are rightly private. The infant life involved, however, is public. But now, or rather starting in 1973 with the Supreme Court, it takes a village to kill a baby. Life, above any other consideration, is public. Oh well, no matter. How much less the meaning of marriage than the meaning of life. And conservatives are polite and will never impose the New Testament commandment to be bold notwithstanding. As it is the scorpion's nature to sting, it is ours to be silent and comply. As I say, there is too much to say. How did this perversion creep into our tent, into our system? It was inserted, like a pasha's penis, into the anus of the judicial system. Inserted by John Marshall, Chief Justice of the Supreme Court, with his effective invention of judicial review, whereby the court, upon the merest majority, may nullify any law. States cannot nullify laws, but the courts can. This is not the federal system we were guaranteed. Oh well. Nullification is not a toxic idea. It may even be a good idea in principle, but it had the effect of making the smallest, least, most inconsequential branch of our federal system into the most powerful. This is undeniably a profound perversion, more perversion, a check without a balance. What business had the court to say a law is unconstitutional? The job was to adjudicate cases under the law, not over it. If the court deemed a law unconstitutional, would not the proper recourse have been to refer the matter back to Congress? Breathtaking in its audacity. So, allow me to state the obvious. Legitimately, the Supreme Court is supreme only over the judicial system. It is not supreme over the Constitution, nor the legislative, nor the executive branch. The President is the supreme executive, and the two houses of Congress are the supreme legislators. See how that works? There are three supremacies, the least of which is the court. Andrew Jackson was a disaster and wrong about almost everything. He was right about the court in his putative statement that the court had made its decision, now let it enforce it. Stalin asked, how many battalions did the Pope have? He also said, 1 death is a tragedy, 1,000,000 deaths are a statistic. Monsters say the darndest things. No government official takes the oath of office to support and uphold the Constitution as the Supreme Court asserts it to be. Rather, it is individual conscience and intellect that must dictate conduct. This very easy fact is made somehow impossible to grasp. Precedent and custom have made this essential conscience to be nugatory. So what remedy? A movement for an amendment to repudiate the specific of gay so-called marriage, or to forbid the Supreme Court from making law and inventing so-called rights? How about flag burning? Hopeless causes can't unring a bell. The gays have invented a new thing, destroyed an old one, marriage. It hath made me mad. We shall have no more marriage. But here's the thing. We cannot have judges dictating the course of our civilization. We can't have that. True, about 2/3 of the states had gay marriage prior to the impositional diktat of the Supremes, but that was largely because state judges had struck down state bans on gay marriage. See how that worked? So it's national, all from judges. So much for the fantasy of democracy. We were fools ever to have used the word. We are ruled by magistrates like imperial China. How then shall we rein in our overlords, this rampant hyper-minority, this quintumvirate, the occasional revolutionary gang of 5, ruddered by whomever happens to be the swinging vote? Well, simply the two now subservient branches of government, executive and legislative, asserting a right of review over the courts. See the symmetry of it? So elegant. Marshall invented the idea into the federal system, and it was a good one, just incomplete and imbalanced. Laws need to be checked for constitutionality, and the Supreme Court would have been the correct body to provide that balance if the Constitution had granted it that power, which it did not. The court also needs to be checked. The president checks Congress via his power of veto. Congress checks the executive via its supposed control over the budget. Where is the check on the court? Mere nomination and consent from President and Congress. This is an initial step. But some of us remember how stealth candidate Souter came to the bench, approved as a conservative and manifesting as a liberal. Initial steps alone were insufficient. Impeachment is a theory, but it addresses wrongdoing, not incompetence or insanity or egregious disregard for the actual, non-breathing, living Constitution that does not have penumbras of emanations. So John Rutledge, a Chief Justice of the Supreme Court during George Washington's tenure, Rutledge tried several times in several rivers to drown himself. He was much deranged and subject to mad frolics. Henry Baldwin, appointed by Andrew Jackson, was confined to an asylum in his 3rd year with incurable lunacy. He remained on the Supreme Court for another 11 years. Nathan Clifford, appointed by James Buchanan, who was a much better president than Biden. Clifford was described by a fellow justice as a babbling idiot. not an invective, a description. He refused to resign and died, a babbling idiot, on the court. Ward Hunt refused to resign because he wanted the pension. He was paralyzed and could not speak. Congress voted him a pension to get rid of him. Frank Murphy, throughout the 1940s, bought illegal drugs from his pusher twice daily. Well, to balance out this frankly anti-American, anti-Constitution imbalance, Congress must assert its power to nullify a word fraught with history, but to set aside odious decisions of the court. Oh, say, Dred Scott or Plessy v. Ferguson, separate but equal. But there is no recourse, no remedy for such perversions except civil war and civil disobedience unto martyrdom. There must be some more political answer, or we are a people not free but subservient, as indeed we are, but should not be. Likewise, the president must assert his ethical and sworn duty to uphold the Constitution as he understands it. Of course we excuse Biden, he doesn't understand. There are several ways to amend the Constitution, but only one that's ever been used, where 2/3 of both the House and the Senate agree to send a proposal to the state legislatures, 3/4 of which agree to make it law. Very high standard. John Marshall did not adhere to such rigor when he amended the Constitution unilaterally by the power of his edict, his diktat. Well, that's the precedent. He did it, so Congress can do it, and the president. Review the court's decisions. We need not amend to curb the abuse ongoing for 2 1/4 centuries. Congress shall assert its duty as an element of its legislative mandate upon a quorum vote of 2/3 or 3/4 of both houses to reverse a decision of the Supreme Court which Congress deems to be obnoxious. Likewise, the president, as the chief law enforcement officer of the land, has the positive duty to enforce laws enacted by Congress and no duty to enforce laws enacted by judges, which in any case is an actual impossibility. Because of the deeply political nature of the office, the conduct of the president in his oversight of the court, the president will be checked by popular opinion, party politics, and imminent elections. Will this happen, the reining in of the imperial court? Yes, it will happen, because the arguments in this video are so powerful, and this video is so virally popular that it is a national power, and it is a force of nature, like a quantum leap and a black hole.